Hi, I'm Jane Dearwester with McIntyre Elder Law, and I had a question today about what happens to jointly owned property if one of the joint owners passes away. Well, I'm going to give you the typical lawyer answer. It depends. It depends how the property was owned. So there are different types of ownership in North Carolina. There are joint tenants with right of survivorship. There are tenants in common. There are other kinds of tenancies. Between married couples, there's a tenancy called tenancy by the entireties. So depending on the relationship between the parties and the way the assets are titled, that is going to dictate what happens when one of the joint owners passes away. So for example, with joint tenants with rights of survivorship, just like it sounds, if one of the tenants passes away, the other tenant or co-tenants immediately gain title to that property when one person passes away. However, in a tenancy in common, when somebody passes away, their interest passes to their heirs. So it doesn't go to the other co-owners, but passes to the deceased person's heirs, which can cause a lot of problems when you're dealing with blended families or sometimes just kind of the average standard families. Sometimes there could be disputes when people suddenly become joint owners of property who weren't expecting to be so in the first place. So it's very important the way you title your property, and knowing what happens to the property after you pass away is a very empowering and very important fact that you need to know. So if you have questions about jointly owned property or other estate planning, probate, elder law issues, please give us a call at McIntyre Elder Law. We're happy to help.